Hello, namaskar, namaskara, namaskaram, namaskar. My name is Pooja Dwivedi. Welcome to my class. Today, in this particular class, we are going to discuss in detail this particular handbook, which has been released by the Supreme Court of India, and it strives to curb gender stereotypes. To understand it, we first need to know what is a stereotype. Under that only, we will be able to understand what are gender stereotypes. You're also expected to understand the difference between gender and sex. There is a difference between these two. Why does the Supreme Court need to release this particular handbook? It understands that as humans, we are filled with subconscious bias. We may not like to accept that we are biased towards a person if we do not know them completely. They must just look like a representation of a sample, but in actuality, they are beyond that. They are an individual. Similarly, judges also have it. Judges are not free from it because it is a conditioning that every child goes through. We have to understand that judgments have a profound impact over the entire country. That is why it is important to use the correct sort of words so that the judges are not perpetuating these stereotypes or gender typical roles. That is why the Supreme Court has done it. Do not need to worry about note making because I provide the notes through my Telegram channel, that is by the name of Pooja Dwivedi UPSC. Other than this, if you want to talk to me about UPSC, you can also join my Instagram channel. Now, let's talk about stereotypes. Stereotypes are nothing but a set of idea or preconceived notion about what someone or something is like. Supposedly, we have a boy or a girl named X. This particular boy or a girl, they belong to a particular society. In this society, it is observed that most of the children have not a very good academic background. They do not have it. So we will have a preconceived notion about this person, X, that they may also not be of good academic background. This is nothing but a stereotype. It can range from religious groups to gender or sex, even to the place where you live at. And this idea is generally wrong because we are judging them on the basis of their subjectivity, on the basis of where they belong to. We are subjective. But if we have to know about them on the individual level, we need to judge them or understand about them objectively. This is what the Supreme Court also wants to do. In any particular judgment, even if the judges are legally correct, they have to ensure that they are not using certain words which are perpetuating gender stereotypes or any other sort of stereotypes. So, it's an assumption or belief that individuals belonging to specific social groups have certain characteristics or traits. This person may be of an intelligent academic background, but because they belong to a specific society which says otherwise, we are just stereotyping them. Now, as you must be thinking that you are not biased. You may not be actively biased, but every one of us have subconscious biases. We may not be a biased individual actively, but passively, if we meet somebody, if we do not know much about them, just few things about them, and our brain starts to develop a pattern. Oh, I also met a person of similar religious group or a similar state or a similar union territory, and they behaved like this. Now, this person who also may belong to a similar religious group or state or union territory, they are also expected to behave in a similar manner. So, everybody has this subconscious bias. But judiciary should be free from it because stereotypes impact the impartiality and the intellectual rigor of judicial decisions. If any judge is biased, even subconsciously, and they have been conditioned, every one of us is conditioned to behave in a certain way, to use certain words from the very childhood. And if the judge also does the same, they may never be able to send a message in the society that this word is actually having a connotation or an underlining meaning to it, which is actually not very healthy for the society as a whole. We should not look at any individual from a subjective point of view, but only objective point of view. So the use of reasoning or language is very important here. That is why there is a list of words which are not acceptable and preferable substitutes have been given for them. I will go through that as well. It also undermines the unique characteristic, autonomy and dignity of the individuals before a court. And this goes against the constitutional principle of equal protection of laws. Supposedly, if any judge is using terms such as devoted wife, married, devoted wife, or they can use terms such as a woman of loose character. So all this perpetuates the preconceived notion that such stereotypes, they are compelling to be accepted. So it goes against the constitutional principle of equal protection of laws, which says that laws should apply uniformly and impartially to every individual, irrespective of the membership to a group or a category. Supposedly, there are two people, A and B. A belongs to a low income background and B belongs to a high income background, and they have caused some sort of financial malpractice wherever they are working. Because B belongs to a well-off background, affluent background, the judges may have a subconscious bias that they do not need to do certain things because they are already affluent. But if we talk about A, who already belong to a low economic background, and they may have also done it, they may have done financial malpractices, the judges may think that of course he is from not a very affluent background, they may have done certain things like this, so they can be fined more rigorously than B. And if they are not able to pay the amount, the fine, to the court, then what can happen? They can be jailed. And hence it will also perpetuate further that yes, look at this person A, he belonged to this kind of background, so correctly so they have been charged and hence jailed. So this is very important for us to understand. This is the subconscious bias that I am talking about. Also, the judgments that are undertaken, they can entrench and perpetuate stereotypes. Entrench as in, if the judgments are using certain words which are not very healthy for the society, such as adulteress, affair, bastard, this will definitely tell the society it is okay for even us to use that. So adulteress has been termed as incorrect in this particular handbook. We can say it is preferred that we should call them women who has engaged in sexual relations outside of marriage, affair, relationship outside of marriage, bastard, non-marital child, or a child whose parents were not married, biological sex, biological male, biological female, it should be sex assigned at birth, born a girl or boy, assigned female or male at birth. Career woman is just a woman. Carnal intercourse is sexual intercourse. Chaste woman is also just a woman. Child prostitute is a child who has been trafficked. They are not mentally and aware and capable. They are not above 18 that they can make that decision for themselves. Concubine or keep, woman with whom a man has had romantic or sexual relations outside of marriage. Dutiful wife, faithful wife, good wife, obedient wife is just a wife. Easy virtue, that means a woman of easy virtue is just a woman. Effeminate, when it is used pejoratively, it is accurately describing the characteristic using a gender neutral term, that is confident or responsible person. Eve-teasing is not eve-teasing, it is street sexual harassment. So thereafter, this is showing us that even the Supreme Court wants to change. Ladylike is actually using a gender neutral descriptive of behavior or characteristic like amusing or assertive. Layabout or shirker is unemployed. So all these words which have been okayed by our society to define any person undermines the dignity of them. That is why it shouldn't be used. Now let's understand the difference between sex and gender. Sex is of course determined by chromosomes. Biologically they can be XY or XX. This is generally a biological thing. Once ones that you see at birth. Gender is a socially constructed and enacted rules and behaviors. That means a person who belongs to a certain sex should do certain things which are socially acceptable. A girl should not laugh out loud. This is a socially constructed rule. A boy should not cry. This is a socially constructed behavior, acceptable behavior by the society. And when, based on the sex, one is expected to do those kind of behaviors which are socially acceptable, this is known as gender stereotyping. Gender is more of a spectrum. There are many women who do not actually are extremely, in a way that the society may accept them to be a woman. Similarly, for boys, for men, it can be the same. There can be occupations as well. A boy should not be a makeup artist. A girl should try to do those kind of jobs which are domestic in nature, taking care of the family, taking care of the husbands. Not, there is also a fact that all women are not maternal. They may not have maternal instincts, but the society says that all mothers should have maternal instincts. Does the society ever ask the men, do they have paternal instincts? No. So this is what the difference is between gender and sex. There is a stereotype. Women are overly emotional, illogical, and cannot take decisions. So how this stereotype will impact the professional career of any woman. A person's gender doesn't determine or influence their capacity for rational thought. All women are physically weaker than all men. While men and women are physiologically different, that is very true. It is not true that all women are physically weaker than all men. This is not true. This is a stereotype. A person's strength doesn't depend solely on their gender, but also other factors such as profession, genetics, nutrition, physical activity. Women are warm, kind, and compassionate. Compassion is an acquired characteristic that can be developed, and it exists in every individual. Unmarried women are incapable of taking important decisions about their life. How does it matter if a woman is married or unmarried? It doesn't actually depend on that. It depends on how they have achieved experience throughout their time in their life. But we have to understand that even the courts were not free from it. A 24-year-old woman's parents initiated habeas corpus proceedings. That means to present the body of, seeking the production of their daughter when she married and moved away from them. And in allowing the petition, the Kerala High Court observed a girl aged 24 years is weak and vulnerable. These two adjectives that were used to define a woman who was actually above the age of 18 years, who was well capable of taking her own decision, although it is socially acceptable that any person, not a man or a woman, but any person who is close to their family can take the advice of their parents and near and dear ones or guardians whenever they are making decision about marriage. This is socially acceptable. It is not mandatory. The Supreme Court reversed this decision in Shafeen Jahan versus Asokan, noting that the High Court was of the view that at 24, she is weak and vulnerable, capable of being exploited in many ways. So this is perpetuating the stereotype that women cannot take their own decisions, or even if they do so, they are under the influence of somebody else. The High Court has lost sight of the fact that she is a major, capable of her own decisions, and is entitled to the right recognized by the Constitution to lead her life exactly as she pleases. The Supreme Court further ruled that the superior courts, when they exercise their jurisdictions, parents patria do so in case of persons who are incapable of asserting a free will. Supposedly a minor is not able to do that, and a person who is unable to make decisions with mental capacity. Okay, moving on. The most important suggestion or case here is the Bhavani Devi's case and the Vishaka guidelines. Bhavani Devi was actually a government social worker, and she belonged to an oppressed caste, and she intervened to prevent a child marriage. Now in 1992, she filed an FIR. And she also gave the testimony that multiple dominant caste men violently assaulted and raped her as a retaliatory measure, to show, of course, that they will remain dominant in every way, not only the caste but also sex and gender. In 1995, the trial court acquitted the accused. And the reasons, let's see them. Members of a dominant caste would not rape a woman from an oppressed caste. Men of different castes would not participate in a gang rape. Older men aged 60 to 70 cannot participate in a gang rape. And it was improbable that a woman could be raped in the presence of her husband. These were the reasons that were given, and this acquittal caused national outrage because of the nexus with Bhavani Devi's work as a government social worker. Now, members of civil society, they filed a PIL in the Supreme Court of India, seeking that workplaces must be made safe for women and that it should be the responsibility of the employer to protect women employees at every step. In 1997, the Supreme Court in Vishaka versus State of Rajasthan laid down the guidelines to protect women in the workplace. And there is also workplace passive subconscious bias that exists. A person, an employer who may want to interview two people for a job. One is a man, another is a woman. This question is very common among the women. When are you getting married? Does it ever occur to the employer they can also ask the men the same thing? Because there is a subconscious bias. This person is very progressive in nature, but there is a subconscious bias that women after marriage may not be as professionally ambitious, which is completely wrong. But various steps have been undertaken by the Supreme Court to show that they are breaking away from the shackles of such thought process. In Joseph Shine versus Union of India, a constitutional bench of the Supreme Court struck down the offense of adultery under section 497 of the IPC. Many people said that the Supreme Court has made cheating, okay, it's not an offense, but cheating or adultery is still a ground for divorce. Why was it struck down is very interesting. Because it penalized a man engaging in sexual intercourse with a woman who is the wife of another man. This shows that that woman who is the wife of another man is actually the man's property. And it did not punish a man who had a sexual intercourse outside of marriage with an unmarried woman. So this was the biggest difference that the Supreme Court cited. The Supreme Court said it punished sexual intercourse with the wife of another man, but not any man who is also having sexual relations outside of marriage with an unmarried woman. What about this bias? The Supreme Court also rejected the pre-vaginum test or the two-finger test and the irrelevance of sexual history in the state of Jharkhand versus Shailendra Kumar Rai. It is said that any woman who has been raped, she has to go through a two-finger test. This is completely unreliable and also undermines the dignity of the survivor or the victim, as they prefer themselves to be called. The testimony of a survivor or a victim is inherently credible. Any court must not be suspicious of any sort of testimony that is being given by the victim or the survivor. If there are certain here and there in the statement, that may be because the person has gone through so much mental harassment. It should not be doubted merely due to incorrect assumptions as well. Women seek to foist false cases against men, or the women lie about having been raped. This is also should not be assumed. This should be first proved and not assumed. In state of Punjab versus Gurmeet Singh, the trial court here refused to accept the survivor or the victim's testimony due to certain preconceived notions because there were inconsistencies. The absence of any physical injuries, it must be evaluated with the context. It can also happen that a woman wasn't able to resist the force that was applied on her to abuse her. Maybe she did not have injuries because of that. And the absence of physical injuries must be evaluated contextually in the facts of a given case. It is not determinative that if she doesn't have injuries, there is an absence of sexual violence. State of Uttar Pradesh versus Chotilal is an important case in this regard, where the Supreme Court observed that the survivor victim had been gagged and threatened with a firearm to maintain relations. So, isn't that sexual violence? Just can be determined by the kind of injuries she has sustained. It's a step in the right direction. Now it is time for us as a society to go through this handbook to understand that words are carrying a lot of heft and energy. That is why we must use them very appropriately and carefully. Thank you so much for watching.